fellow peers and lecturers. We are Group 13. Today we are going to talk about undue influence and how it affects third parties as well as relations. In Malaysia, undue influence is governed by Section 16 of the Contracts Act 1950, reflecting English law. According to Section 16, subsection 1 of the Contracts Act 1950, a contract is said to be induced by undue influence, where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses their position to obtain an unfair advantage over the other. In simpler terms, this means to say that one of the parties need to be on the same level and not gaining any benefits more than the other. According to Section 10, subsection 1 of the Contracts Act 1950, all agreements are considered contracts if made with free consent from competent parties. This means to say that willingness plays a key factor for both parties to enter into contract willingly. According to Section 13 of the Contracts Act 1950, free consent is defined as consensus ad idem, meaning that all parties agree on the same subject. This means to say that there has to be a meeting of minds according to the Latin phrase consensus. Now, moving on to Section 14, paragraph B of the Contracts Act 1950, consent is deemed free unless it is influenced by undue influence, as described by Section 16 of the Contracts Act 1950. Now, following on, in this case, whether there was consensus ad idem between Bahari and Harith is questionable. Harith agreed to donate the 100,000 ringgit with the exception of becoming the club's president, but Bahari, who disliked Harith, likely knew he would not fulfill this promise. Thus, the basis of Harith's consent may be tainted by Bahari's influence and deception.
Section 16 of the Contracts Act 1950 defines undue influence in Malaysian law, a definition that aligns closely with English law as clarified by Tunku Abdullah. To establish undue influence, two limbs must be proven under Section 16, subsection 1. The first one is position to dominate. One party must be shown to be in a position to dominate the will of the other party. The Privy Council in the case of Pusaturai and Kanapa Chettiar clarified that mere influence is not enough. In this case, it is stated that the influence must be undue. That is, the influence is used to gain an unfair advantage. In Malaysia, similar confusion in judgments may arise when terms like unconscionable conduct or unfair advantage are referenced, highlighting a lack of precise scope on what constitutes unconscionable behavior. The second limb is unfair disadvantage. The dominant party must have used their influence in a way that places that influenced party at an unfair advantage. Under Section 16, subsection 2, a person is considered to be in a position to dominate the will of another if certain conducts are met. For example, in the case of Rosli bin Darus, Harun bin Haji Saad, and another, the court noted that the domination may be proven by direct evidence. A fiduciary relationship is defined by Lord Justice Millett in Bristol and West Building, Society and Motive as one in which the fiduciary has agreed to act on behalf of another in a way that creates a trust-based relationship. The fiduciary's primary duty is loyalty, meaning they must put the principal's interest first, avoiding conflicts of interest. Presumption of fiduciary relationship exists in certain cases, such as between a parent and child, or solicitor and client, as seen in Public Finance, Berhad versus Lee v. Rubber Factory, and Kara Rajarantam versus Datuk Jaginder Singh and others. Kao Chung Poon and others versus Kao Chung Bok and others provides another example under Section 16, subsection 2, where domination of the will could be presumed because the deceased was totally dependent on the defendant before his death. In the same section, where one party contracts with someone whose mental capacity is compromised by age, illness, or other distress, however, this subsection is not relevant to the current case facts and can be disregarded. Section 16, subsection 2 serves as an illustration of the type of scenarios where a person might dominate another's will. Under Section 16, subsection 3, once undue influence is shown, the burden of proof shifts to the alleged wrongdoer. It is then their responsibility to demonstrate that the influenced party entered into the transaction of their own free will.
Under actual undue influence, Tritel defined it as situations where one person pressures another into an agreement in a way that equity or fairness finds improper even though it isn't legally defined as duress. In other words, persuasion isn't necessarily wrong, but if the pressure is so intense that it overpowers the person's free will and stops them from thinking independently, then it becomes undue influence. Even though no force or threat is used, the person's freedom to make a genuine choice is taken away, which makes the agreement unfair. In the case of Alcott and Skinner, Lindley, Lord Justice, stated that the basis of the doctrine of undue influence is not to save persons from the consequences of their own folly, but to save them from being victimized by other people. The Alcott case also establishes two primary categories. Class 1, actual undue influence. Now this, the claimant must prove that the other party directly exerted undue influence, causing them to enter the specific disputed transaction. Another class would be Class 2, presumed undue influence. Now in this one, the claimant only needs to show a relationship of trust and confidence with the other party, allowing a presumption of undue influence over the transaction. The burden then shifts to the other party to show that the claimant entered into the transaction freely.
Moving on to presumed undue influence, in Bank of Credit and Commerce International SA and Abudi, the Court of Appeal recognized these categories and further divided presumed undue influence to two classes. The first class, being Class 2A, certain relationships automatically presume undue influence by law. In the case of William and Bailey, the agreement was voidable because the actual undue influence exerted by the bank on the father by threatening to prosecute his son. In Class 2B, claimant must show that there are an existing relationship of trust and confidence or influence between the parties that it raises presumption that the wrongdoer exercised undue influence on the weaker party. In the case of Royal Bank of Scotland and Aldridge, number 2, Lord Nichols explains that having influence isn't enough to prove undue influence. There has to be something that raises suspicion about why the person agreed. If the decision seems unfair or heavily favors the person with more control, that person has to give a more convincing explanation. The more unusual the agreement, the stronger the explanation must be to prove that there is no undue influence. Ultimately, the victim has to show that undue influence likely occurred.
This decision was upheld in the House of Lords case of Barclays Bank plc against O'Brien. To successfully rescind a contract under Class 2 undue influence, the following steps must be met. The first step, proving a relationship of influence. Either a pre-existing special relationship that automatically gives rise to a presumption of influence, Class 2A, or a relationship of trust and confidence that supports a presumption of influence over the specific transaction in question, Class 2B. To show that there is a transaction that calls for an explanation, the court examines the transaction's nature to see if it raises suspicion. If so, a rebuttable presumption of undue influence arises, meaning that the influence is assumed unless proven otherwise. The third one, shift of burden to the dominant party. The burden shifts to the dominant party, who must provide a strong and logical explanation to rebut the presumption and demonstrate that no undue influence was exercised. Furthermore, the burden shift in Malaysian law serves as a proactive measure for weaker parties, allowing them to challenge transactions where undue influence is suspected without needing extensive proof. Furthermore, this approach is particularly beneficial in relationships with inherent power imbalances.
When talking about the similarities of UK and Malaysian law, both recognizes undue influence as a use of a dominant position to gain an unfair advantage over a weaker party, undermining genuine consent. Under Section 16, Subsection 2 and Subsection 3 of the Contracts Act 1950, it's similar to the presumed undue influence under the English law. In the case of Pestisio versus Huet, Lord Justice Memory illustrates setting aside a contract for undue influence is not about providing the defendant's wrongful conduct, but on preventing abuse of trust as a matter of public policy. He establishes when a relationship of trust is used to exploit the weaker party, and if the transaction benefits one and appears disadvantageous to the other, it requires an explanation showing such a decision were made with clear, ordinary motives. In comparison with UK law, there is no need to prove manifest disadvantage. It's enough to establish undue influence by an unfair power imbalance.
As discussed earlier, there are two limbs to be proven in application to the case to determine if Bahari was in a position to dominate over Harith's will. We can refer to Section 16, subsection 2 of the Malaysian Contracts Act of 1950. This section outlines when the courts consider someone to be in a dominant position. Dominion can be proven through direct evidence or be presumed, especially when one party is completely dependent on the other, which shows a power imbalance. Cases like Rosli bin Darius and Mansur Harun bin Haji Sa'ad and Kau Cheng Poon and Kau Cheng Bok discussed earlier illustrates this point. Distinguishing their relationship, we can refer to the concept of fiduciary duty explained by Lord Justice Millett, which we explained earlier, where a fiduciary is someone who acts on behalf of another in a relationship of trust and confidence. Now, based on facts, Harith viewed Bahari as someone who he had always admired and turned to for advice. Moreover, the facts also state that Bahari knew of Harith's financial situation, suggesting that they had some form of a relationship of trust and confidence. Thus, a fiduciary relationship can be established in this case because Bahari, as president of the club, had influence over Harith, promising him a future position despite knowing his financial difficulties. Therefore, for Harith to be successful in his claim, Harith must prove that Bahari had used that dominant position to gain an unfair advantage over Harith. Now, to apply it to the facts in question, can be distinguished from the case of Pusaturai and Kanapa Chetia, where the court could not find undue influence because unfair advantage was not proven. Here, the facts show that Bahari used his dominant and influential position to persuade Harith to donate 100,000 ringgit, despite knowing Harith's financial struggles, with the promise of making him the club president. Additionally, there was no guarantee that Harith would actually become president, as the outcome of the club members' votes was uncertain, and therefore indicating that by unduly influencing Harith, Bahari did gain an unfair advantage.
But what advantage did Bahari receive? The donation given by Harith allowed Bahari to leave his presidency on a good note, as he would be credited with obtaining substantial funds for the clubhouse. This achievement would reflect on his leadership, enhancing his reputation and legacy among the club, as someone who made a lasting and positive impact on the club just before stepping down, while Harith did not gain nothing but just a loss of Rm100,000. In conclusion, Harith is likely to prove undue influence under Section 16 of the Contracts Act 1950, as he has proven that Bahari did have a position of dominance over his will and used it against his advantage, thus creating a rebuttable presumption under Section 16, subsection 3 Contracts Act. The burden shall now be shifted to Bahari to prove the contrary, that Harith had entered into the contract on his own free will. On the assumption that Bahari fails to prove the contrary, the courts are likely to grant a rescission under Section 66 of the Contracts Act 1950, where the dominant party too must be restored any benefit he received from the victim to the victim, or he must compensate the victim for the benefit interpreted in Yong Mok Hin and United Malay States Sugar Industries. In English law, the outcome using the UK common law would bring us to the same position, as it can already be established that Bahari holds a position of dominance. Although English law focuses more on the influence itself rather than the unfair advantage, the facts of the case suggest that Bahari used his dominant position in a way that calls for an explanation. It raises question on why Bahari would persuade Harith to donate Rm100,000, especially considering he knew about Bahari's financial difficulties. Additionally, Bahari leveraged Hari's ambition to become the president of the club to influence his decision, further highlighting the manipulation involved in this situation.
I am going to explain the law regarding third parties and undue influence in Malaysia and in the United Kingdom. Following the case of Malaysian French Bank and Abdullah bin Muhammad Yusuf, the High Court held that undue influence can only be raised by the party in the contract and not the third party based on the Bank of Montreal case, which is inconsistent with Section 16 of the Contracts Act 1950. Thus, there is a lacuna within the law. Therefore, based on Section 3 of the Civil Law Act, courts may refer to English law in regard to this matter. Under the English law, a contract with undue influence from a third party can be avoided if the third party was acting as the other party's agent, or if the other party had knowledge or other notice or constructive notice of undue influence exerted by the third party. In addition, it must be proven that there was undue influence by the third party. In the case of CIBC, could still enforce the charge because the husband was not acting as CIBC's agent. CIBC had no actual notice of the undue influence, and CIBC had no reason to suspect undue influence as the transaction appeared to benefit both the husband and the wife. In the case of Barclays Bank and PLC and O'Brien, constructive notice was established. Constructive notice is applicable when a party should have been investigated but was failed to do so, basically turning a blind eye to potential misrepresentation or undue influence. Lord Brown Wilkinson offered a rationalization for the constructive notice stages. Firstly, being put on inquiry. A creditor is put on inquiry when a wife guarantees her husband's debt if the transaction appears to not benefit the wife. There is a substantial risk that the husband misled the wife to secure her agreement. The second one is the creditor's duty when put on inquiry. If there is a risk of misrepresentation or undue influence, the creditor must prove it took reasonable steps to ensure the surety that the wife agreed and understood freely to the situation. This includes awarding the surety a loan of the liability and advising them to get independent legal advice. Furthermore, in Royal Bank of Scotland and Ettridge No. 2, Lord Nichols established a detailed guideline for the banks when dealing with sureties in non-commercial relationships to avoid constructive notice of undue influence by the third party. Banks are put on inquiry whenever the relationship between the debtor and the surety, for example, a spouse, is non-commercial, indicating a potential for undue influence. Secondly, independent advice is a requirement. The surety should receive advice from an independent advisor, usually a solicitor. The bank's steps include directly communicating with the surety to confirm whether she wants a solicitor who can be the same as that for the debtor, or providing the solicitor with all financial details of the transaction, informing the solicitor if there is any suspicion of undue influence on the surety, and it requires written confirmation from the solicitor that the transaction and its implications have been fully explained. Face-to-face meeting with the solicitor is necessary if the surety chooses for independent legal advice. A face-to-face meeting must take place where the solicitor should explain the transaction in clear, non-technical language. This explanation should cover the nature and the consequences of the documents, including the risks, for example, potential loss of the home, the seriousness of these risks, clarification that the decision to guarantee is solely the surety's choice, and asking the surety if she wants to proceed or if she prefers further negotiation from the bank.
Now, I'm going to apply the law in regards to the second issue, Harriet and Wendy. First, we need to establish whether Harriet exerted undue influence on Wendy. For undue influence to be established, the law requires us to determine whether Harriet in fact had a position of dominance over Wendy's will. This is seen in HSBC and Sharikat United Leong Enterprise and another. In order to determine this, we can refer to Section 16, subsection 2 of the Contracts Act 1950, which lays out situations where a person is deemed to be in a position to dominate. Following the facts, Harriet said that should not be a problem. She always listens to me, to the bank, and although in the past Wendy would do whatever he asked her to do. This shows that Harriet had some form of dominance over Wendy that led him to believe that she would listen to everything he would ask her to do. It can be argued that although Wendy initially refused, she eventually went to the bank and signed the documents. However, she only signed the documents because Harriet manipulated her emotions. Harriet was sulking, and his expressions of disappointment led Wendy to reluctantly change her mind. The fact that she's reluctant is crucial here, as it suggests that Wendy hesitated because she didn't fully trust Harriet's decision. However, as Harriet's wife, she may have felt a sense of duty or guilt that H exploited this to influence her into signing the charge document. This manipulation essentially pressured Wendy into taking an action she was initially uncomfortable with, a strong argument of undue influence. Therefore, it can be proven, just like in the cases of Rosli bin Darus and Mansour and Kao Cheng Bok and Kao Cheng Poon, the presumption of real and apparent authority would apply to the case at hand. In regard to fiduciary relationships, the case of Public Finance Berhad and Lee B. Rubber Factory provided classes of relationship that gave rise to the presumption of being in a dominant position, which includes solicitor client, parent and child, but it did not include the relationship of husband and wife. In a marital relationship, the natural affection and trust between spouses do not automatically constitute as undue influence. Although Wendy's and Harriet's relationship doesn't amount to fiduciary, it can be concluded that Harriet does have real and apparent authority over Wendy, and he used his position to gain an unfair advantage in this case, as the access to loan raised funds for his company and nothing for Wendy. Furthermore, we need to establish did Harriet act as an agent to the bank, or whether the bank had actual or constructive notice of Harriet's undue influence. Based on the facts of this case, the bank is likely to be put on inquiry as the nature of Wendy and Harriet's relationship isn't commercial. Based on the case of CIBC mortgages and Pitt, the court considers three factors in situations of undue influence is alleged. In this case, there is no indication of Harriet acting as the agent of the bank. However, in the case of Bank of Scotland and Edridge, the guidelines emphasize that an independent advisor, typically a solicitor, should explain the transaction to the surety, in this case Wendy, with the bank responsible for arranging the advisor if there is a risk of undue influence. Here, the bank failed to provide independent advice to the wife, Wendy, despite clear indication of potential undue influence. The bank requested security for a loan, and Harriet responded, "It shouldn't be a problem. I'll ask my wife to charge her house. She always listens to me." This phrase is significant. It suggests that Harriet was confident that his wife would agree without question, speaking on her behalf rather than consulting. However, here, Harriet assumed she would comply without consultation, indicating potential undue influence. Furthermore, none of the other procedural guidelines from the case of Bank of Scotland were followed. The loan did not benefit Wendy in any way, as it was taken solely to raise funds for Harriet's company, which is facing financial difficulties. Therefore, despite having notice of Harriet's undue influence, the bank failed to take the necessary precautionary measures to protect Wendy's independent consent in this transaction.
Therefore, to conclude, in short, Wendy is likely to be able to prove undue influence under Section 16 of the Malaysian Contracts Act 1950, as she can prove that Harriet did have a position of dominance over her and her will, and used it to gain an unfair advantage. thus creating a rebuttable presumption under Section 16, subsection 3. The burden shall now shift to Harriet to prove the contrary, that Wendy had entered the transaction through her own free will. Moreover, if Wendy's claim succeeds, she can attempt to claim for the remedy given by Section 20 of the Contracts Act 1950, as it can be shown that her contract was influenced by Harriet's undue influence, and that the bank failed to take any precautionary measures to ensure her independent consent. Under Section 20 of the Contracts Act 1950, if someone consents to an agreement which was obtained through undue influence, they may have the right to cancel the agreement. However, if they have already gained a benefit from the agreement, the court can set fair conditions to cancel at any time, aiming to return both parties to their original position as much as possible, also known as rescission.